All right, hello everyone, and welcome to Professor Sankoff's Case Alert. This is Case Alert number 35, and we have a special Supreme Court case preview today. I am joined by Gerald Chan of Stockwoods, and it's a special one because both of us are appearing for interveners in the case of JJ, which we are going to preview in this Case Alert. I have to tell you, if you watch my case alerts, you know I'm not regularly prone to hyperbole, but I do think this is one of the biggest cases of our generation. It will set down some major thoughts and principles about the way in which the defense has to act in sexual offense cases, but arguably with principles that can be extrapolated across the board. I'm going to very briefly introduce the legislation that is being considered in this case. You are probably by now familiar, unless you've been under a rock, with section 278.92 of the Criminal Code. It says that in proceedings involving sexual offenses, no record relating to a complainant that's in the possession or control of the accused is admissible unless you go through the regime. And I'm not going to go through the regime in detail, but it's essentially like a section 276 application. It applies to any records for which there is a reasonable expectation of privacy. The procedure is as follows. It is an application in writing with detailed particulars of what the evidence is and how it's relevant. And generally speaking, the application has to be held pre-trial. That is an issue in this case as well. But generally speaking, like a 276, it's done prior to trial unless the judge holds otherwise. The complainant has the right to be represented by counsel at the hearing to admit the evidence. Now, as you know, this has been challenged constitutionally across the country. There has been a mixed bag of rulings on each side saying, yes, it is constitutional, or no, it's not. At the end of the day, two cases were got up to the Supreme Court at the same time. The first is JJ, a case out of British Columbia being appealed by the Crown, who lost the ruling at trial. And the second is AS, which is actually an appeal by a complainant in the hearing who felt that their interests weren't properly respected by the trial judge. Very briefly, again, this is the way it works. If the record involves sexual activity, it's just like a 276 criteria. Otherwise, it's admissible if it's relevant and has significant probative value that's not substantially outweighed. So in effect, the balancing process is against the probative value of the evidence versus the privacy interests and other things of the complainant. Have I summed it up generally correctly, Gerald?
Yeah, no, that all sounds right to me.
Okay, fantastic.
At least in terms of what the legislation says, not in terms of its constitutionality, but we'll get to that.
That is correct. The hearing is next week. It is a 2-day hearing. And if there's anything that excites me, Gerald, it's sitting on Zoom for 2 full days so I can make a 5-minute argument. That is going to be a wild time. If you're wondering who's intervening in this case, it's easier, I think, to ask at this point, Gerald, who isn't intervening in this case. I think I can sum it up by saying every attorney general, just about every major defense lawyers organization is now more or less in, and quite a few, of course, LEAF and some affiliated groups are also in. I think it's a big party. Is there 20 parties in this, Gerald? Something like that?
It's something I just spent the weekend reading everybody's factums, and so it was a pretty unwieldy process.
Yeah, I'm still going through that, but let's talk about for our viewers like what this case is really about. I've suggested it's one of the biggest cases of our time, really. Gerald, what do you think is really at stake in this case? If you could sum it up.
I think this really gets to the core of the right to a fair trial on the part of the accused in sexual offense cases, because so many fundamental criminal law principles that we at times take for granted, but even when we don't take for granted, we really view them as essential to the right of an accused to a fair trial. So many of those are implicated in this case for sort of the subsets of sexual offense prosecutions that this regime applies to. And so, I mean, you've summarized the different pieces of it, but just to take one component of it, one of the fundamental principles that we understand in criminal law is that there's the right to silence on the part of the accused. There's a principle against self-incrimination. So the accused is entitled to sit back and force the state to make out its case, to establish his or her guilt beyond a reasonable doubt with evidence admissible in an open courtroom. And the defense does not have to provide disclosure of its arguments, its evidence, its case to the prosecution and to the prosecution's witnesses, in particular the complainant in a sexual assault case, before trial and before that witness or complainant testifies and before cross-examining that witness or complainant. That's all been somewhat upended by this regime for the subset of cases to which this statutory regime applies. And so now you've got a situation where if the defense is in possession of records, which you captured the definition of really anything in which there's a reasonable expectation of privacy, then the defense has to bring a pre-screening application to get judicial permission to use the records. But not only that, it's not just an application that's on notice to the Crown. I guess that would be one thing, but it's an application that is on notice to the complainant because the complainant has standing as of right to appear and make submissions at the hearing through counsel. And so now you're in a situation where the defense essentially has to preview the impeachment material, because that's what they would be using the records for in all likelihood, preview the impeachment material and the line of cross-examination, because the defense has to explain to the judge why they should be permitted to use these records. So they're previewing essentially the defense strategy for the very witness that they're seeking to cross-examine in the case, and whose credibility is often central to these types of cases. And that's really a sort of a real significant upending of how we run criminal trials in the ordinary course.
Yeah, that's the impact. Also, that's the focus of the submissions that I'm making to a certain extent, and I think you are. And I'm going to ask you a little more about the CLA position. To me, that is, of course, you've outlined what is at stake. To me, from a constitutional perspective, one of the things that I think is most important and why this case is so significant is most of the things that this legislation does received constitutional approval, in this case, Darich, that dealt with Section 276. And if I could sum up the attorney generals across this country effectively of what their position is, because as I read it, is Darich said this is okay, so therefore it's okay for everything. Like, that's sort of as I see their position. And what worries me so much, and why I think this is such a landmark case, is I think there's a small chance the Supreme Court could buy this idea. But essentially, to explain it to the listeners, just to focus on the issue that I'm most interested in, the right to silence, as defense lawyers know, normally you turn over nothing to the Crown. Darich says it's constitutionally okay to have to turn over some material because it's only a tactical burden. If you don't want to bring a 276 application, you don't have to do it. The Crown has effectively adopted that across the country and said, well, therefore we can impose that tactical burden on this evidence too, without considering the special nature of what 276 is designed to protect. Do you agree with me that bigger principle, what really worries me is, I believe that if the Supreme Court adopts that reasoning, there will be more defense disclosure coming across the board.
Yeah, no, I completely agree with you. And I know you really go at this in your factum in the JJ appeal. And I completely agree. I mean, this is the danger of lifting words out of context, right? Where you've got this language in Darich about, we don't allow trial by ambush, and this is just a tactical burden, not a legal burden. But that all comes up in the very specific context of 276, where you've got evidence of other sexual activity that is
separated from this trial, really, right? Because it's sexual activity.
It's extraneous. It's presumptively inadmissible. It's especially prone to reasoning by myths and stereotypes. And so we allow this, special set of rules in that narrow circumstance. And as you pointed out in this case, you've now got the Crown and other attorneys general lifting that language from Darich and saying, well, it applies equally here. And you sort of take that reasoning to its logical conclusion. It's like, how far does that go? And does the exception just end up following the rule entirely?
to infinity, because in theory, what I argued when we did this at the trial, which the trial judge really accepted in the JS case in Alberta, was that if the Crown's right, if I'm Parliament tomorrow, I'm just going to say that the defense now has to supply particulars of its defense before trial. And if they don't want to adduce any evidence, they don't have to. So they don't have to do it. It's just a tactical burden. And I don't really
Yeah.
see any distinguishing feature between those two things. The Crown would argue that, well, Section 278.92 covers more important interests, but it's not. Either you're looking at the nature of the evidence that allows this to happen, or you're not. And I don't think they think that we should. So that's something that concerns me a lot.
No, I think that's right, and that does get to the sort of the distinction between, other sexual activity in 276 and records in 278.1, right? I mean, other sexual activity, that's a category that's really driven by the nature of the evidence.
Right.
And we now know from, Barton, that it applies not just to the defense, but the Crown can't lead that evidence without going through a special procedure. That's not true of records under this regime. It's not driven so much by the nature of the evidence, I would argue, but just by the fact that there's a privacy interest that the complainant has in this type of document. And it doesn't apply equally to the Crown. It applies only to the defense.
Well, it has to be that way, just in case people are confused by what we're saying. I mean, a record could include anything from a text from the complainant to the accused saying, I know you didn't do anything wrong last night, which would be pretty exonerating, right? To more peripheral or invasive private materials that are a little less connected. The point we're making is that the probative value is so variable in records because they're not a class of evidence, they're a class of material.
That's right. That's
yeah.
right. And I mean, and I know we'll get to the definition, the scope of the definition of records, but if you construe it that broadly, it will oftentimes. I mean, I just one of my recent cases involved records, as the Crown argued, applied to text messages that were about the specific sexual encounter that was the subject matter of the charges. They were texting, the same day after the incident about the incident, right? And so that's incredibly probative. Is that subject to this regime where you've got? Well,
by the way, that is, Gerald, a topic for another day. But I will tell you that I just did a talk recently with Deborah Hatch about 276, and the same thing is going on in 276. I call it 276 creep. I am not a huge fan of Darroch, but I'm prepared to accept the core holding in Darroch as long as it relates to sexual activity as we construed it at the time. Sexual activity now is just becoming this massive, massive scope of material. And the more you bring in, the more I think the constitutional holdings become suspect.
Yeah, no, I think that's right. And I mean, what made, I think, the Crown's arguments in Darroch in cases like that more compelling before was the fact that they were focused just on this exceptional category of evidence that was especially prone to reasoning by myths and stereotypes. So that's, what made their argument so compelling is now being sort of whittled away to expand the scope of it.
Well, I'm just going to say that is, I put my scholar hat on for a moment, but I just will say it's not the first time I've seen that, where the constitutional holding that upholds the validity says all these wonderful things about restriction and scope and interpretation, and then the implementation of that law down the road tends to depart a little bit from what some of the core constitutional holdings actually were.
Yeah.
Anyway, that worries me here too. What is can you tell me what is the synthesis of, or the focus of the CLA's position in this case?
Sure. So, I mean, we take as our starting point that we agree that this regime is constitutionally flawed. But we, given we're an intervener, there's lots of other interveners, and the parties are making, compelling arguments about the constitutionality of the regime. So we've focused our factum, and will likely focus our oral argument time on a more specific issue, and that is, in determining the constitutionality of this regime, you've got to interpret it, you've got to understand its scope, and we're arguing that records, as defined in the statute in 278.1, properly defined, don't apply to text communications, electronic communications between the accused and the complainant, and so that there's a statutory interpretation way out of this overly broad concept of records. It may apply to other documents, and what we would say it was intended to apply to other documents. I mean, it's funny. Most people think of this regime as sort of the Ghomeshi, the Ghomeshi rules, because I think the timing of it and how sensational the Ghomeshi case was. Exactly, it arose out of Shearing a long, long time ago. It's been in the works for a while. It just didn't get passed until more recently. And Shearing was about a personal diary. It wasn't about emails or text messages, right? A diary that just happened to fall into the possession of the accused. And so, fine, we have this regime that says, well, just because a document or a record like a diary happens to fall into the possession of the accused doesn't mean that the complainant has lost all privacy interest in it, and there should be some pre-screening application in the way that there would be had the diary remained in the complainant's possession. And so that's a very specific circumstance. But if you look at all the Parliament could have easily amended the definition of records. They could have expanded it. They could have referred explicitly to text communications. They don't, despite referring explicitly to a number of other different types of records, like the diary and Shearing, like medical records. And most of the records in that definition either fall into the category of something that was only ever meant for the author's eyes, like a diary, or something for which there's a professional obligation of confidentiality, like medical and therapeutic and psychiatric records. Text communications between the accused and complainant are entirely different from that, right? I mean, they are not just voluntarily shared with the recipient. They are created for the specific purpose of being delivered to and read by the recipient. And so our argument is, how can you say that in this context that there's a reasonable expectation of privacy, the complainant has a reasonable expectation of privacy vis-a-vis the recipient, the intended recipient of those messages, who's now seeking to use them to make full answer and defense to allegations that the sender of the messages has made against that person. It's a very different situation, we would argue, from other contexts.
Yeah, well, I have 2 points to make on that. First is that not only is it a very different situation, what the case law clearly demonstrates is that it is the overwhelming majority of the applications that have been brought concern that type of information, right? I mean, it's not even close. Yeah. There are some other records here and there, videos occasionally, but it's almost always text messages. Is that fair to say?
I think so. Certainly in my experience, and it's no surprise, right? I mean, everyone texts these days, and so anytime, and if you've got a sexual assault allegation arising out of a situation where the two parties know one another and aren't complete strangers, chances are they're going to have text messages between one another before the incident, after the incident, that relate to the incident, and that are probative, and that the defense may want to seek to use at trial. So yeah, this is coming up all the time.
Yeah, I think so too. And I have my second point on this is, well, I have 3 points, I guess. So my second point on this is that I obviously share your view of that, of how it should be interpreted. I don't understand how it ever got this far, although I do understand, because generally speaking, I think it's also fair to say that the rulings on this point across the country don't tend to favor your position. Is that correct? Like there are some that go close to it, but most do not.
Yeah, I mean, it's sort of a mixed bag. I think that's probably fair if you were to add up the number of decisions on one side that have said text messages between accused and complainants do attract a reasonable expectation of privacy for this purpose in our records, and then you add up the cases on the other side. I mean, part of the confusing thing too is a lot of the cases, the ones that are more favorable to our position, don't go as far as we would like, in that they
Correct.
say
they don't get they get into the content, right? More.
Yeah, and that's something that we're gonna try to focus on here, because I mean, reasonable expectation of privacy traditionally under the search and seizure context is supposed to be content neutral. Right? You're just looking at the class or the category of records. You're not looking at each individual text message. And we're going to argue it should be the same approach here. And you can imagine how unwieldy this process will get if we're in a framework where we have to look at the content of every text message. We're going to have motions for directions.
We know how unwieldy it is. It's happening in some jurisdictions.
Well, you're going text by text, right? You're going to have to ask the judge to look at every text, every conversation, and in a case where the complainant and accused have been in, let's say, a marriage or some other longer-term relationship, they're going to have, I don't know how many text messages between them over the course of the relationship that a judge is going to have to filter through one by one, and it just becomes, extraordinarily time-consuming process, a complicated one.
Yeah, I tend to agree, though. Of course, it gets even more complicated when you throw Section 276 in there. So anytime the text communications have a sexual connotation, it triggers the other regime as well, right? But I mean, I certainly
That's right.
share your point, and I am not a betting man where the Supreme Court is concerned. But if I were to bet, that is the way in which they can keep both parties generally happy. Does that make sense? I think there is a way for them, if they accept that position, they can uphold the bulk of the law without really digging into it. The Crown can walk away and say the law is upheld, and the defense can walk away and say, well, the law is pretty much restricted to very minimal situations. That is the middle route if the court chooses to go that way, is it not?
It's certainly one of the middle routes, and I think it may be, one of the more significant ones. I mean, we've seen other middle routes come up in the lower court case law, right? Like, for example, this whole timing issue, right? Delay of when under the statutory regime, it says you got to bring these pre-screening applications 7 days previously, which most courts have understood and interpreted to mean 7 days before trial, which is what creates the constitutional problems our side of the courtroom is saying. But so you've got some decisions, most notably a decision of Justice Breen's in Ontario, saying, well, I'm going to interpret that to, it says 7 days previously or some shorter, interval of time as the interest of justice may require. And so as a matter of statutory construction, I'm going to interpret that to say that the trial judge ought to exercise their discretion, allow these applications to be brought mid-trial after the complainant has testified in chief, so that at least their evidence is to some extent locked in before the defense has to preview its cross-examination materials for the court and for the complainant. So you've got, there certainly does seem to be, I mean, there's such a wide range of views on these issues across the country, from saying it's unconstitutional to saying it's constitutional and interpreting it strictly, to saying, well, there's a middle way to interpret this here to uphold its constitutionality, but to sort of narrow its scope so that it doesn't completely whittle away the constitutional rights we're worried about.
And what's so kind of amazing about this, you're absolutely right. There are just decisions all over the map from courts across the country, and yet not a single appellate decision on the matter.
Until the Supreme Court of Canada.
Issues.
Until the Supreme Court of Canada. This is one of those weird cases, right, where we sort of skip past the provincial courts of appeal.
I just want to wrap it up by finishing in a sense where I started. To me, there's no way to decide this case that doesn't involve a major alteration to the way we think about certain principles in the charter. And I say that, Gerald, because I really do, as you know, I've championed the view that you're taking on this appeal. That's not the arguments I'm focusing on, but I've raised those arguments unsuccessfully at the trial level as well. And what I would say is the decision that the position that you're taking impacts Section 8 law as well. It impacts the way the court construes the reasonable expectation of privacy. I have no doubt you're relying on Marica and cases like that and Reeves. And so it seems to me that if they take your line of argument, it does one thing. If they don't take your line of argument, it arguably creates some different Section 8 issues to be resolved at a later time. And of course, depending on what they do with what we were discussing earlier, the tactical burden and such, there's just some real potential changes to the system as we know it. I don't want to overstate what the impact is, but there's no question that this case has real scope and impact for all defense lawyers down the road.
No, I completely agree. I mean, I'm teaching criminal procedure at U of T right now. And I mean, this case, you're right, the spillover effects, both the holding and then the spillover effects of what the court says, even in terms of just the dicta, are going to affect, right, not just Section 7, not just certain principles under Section 7, but Section 8, et cetera. And it's going to have serious ramifications, I think, for how we think about fairness when it comes to criminal trials.
Yeah, I think that's true. And it gives me a little, that's why there's no doubt as we go into this case next week, I'm aware of the stakes. I know Gerald is aware of the stakes. I know our friends, Megan and Rebecca, who are the principal lawyers for JJ, know the stakes. Ironically, I'll just point out to everybody, it's kind of an interesting case for both Megan and Rebecca. They don't have to worry about their clients. Their client has been acquitted and is no longer part of the proceedings. And he's not at risk at all in either way, right? So they've got a little. I know about you, when I go to the Supreme Court on those rare occasions, I always feel the client's weight on the shoulders, so they can argue free of that weight, which is great. And I know there's
Yeah.
going to be some real fantastic arguments, but there's no question that the hairs on my neck are standing up because I'm aware of what's at stake in this case, and it's going to be a hell of a hearing.
Well, we'll have a fun 2-day hearing next week, and hope that justice prevails.
All right. Thanks very much, Gerald. It has been such a pleasure. Thank you so much for coming on to my case alert. And I know this will be of use. It's going to go out. We usually record these well in advance, but this is going out this Friday because the case is next week. And I hope everybody gets a chance to learn. So thanks so much for coming on, Gerald. I appreciate it.
Oh, thanks for having me.
All right. I am going to stop recording.